Everyone. My name is Monica Barrett. I'm a partner here at Bond, Schoeneck King, and I'm a member of the Higher Education Practice Group. I want to welcome you here to the program on cybersecurity and current healthcare environment. It's jointly presented by Bond, Schoeneck King and Kroll North America. I'm welcoming you here in New York and in our Albany office, Syracuse office, and a welcome to the Buffalo office. A recent study has shown that healthcare organizations are 114 times more likely to be hit by ransomware infections than financial firms, and 21 times more likely to be hit than educational institutions. Why are healthcare organizations such a prime target for ransomware attacks? Many of you here probably know. Here are three possible reasons. One is that healthcare organizations are more likely to be nonprofit, and there may be a perception by outsiders that you spend more money on patient care than you do on cybersecurity. A second possible reason is the obvious one, that healthcare organizations have valuable data. Your data includes personal information like Social Security numbers, home addresses, names of relatives, and all kinds of information that make you vulnerable to attack. And finally, another reason is that healthcare organizations are likely to pay a ransom if you're under attack by a ransomware attacker. And you are likely to pay money because it's a life or death situation when you cannot get access to your healthcare records. Just 2 weeks ago, the U.S. Department of Health and Human Services, Office for Civil Rights, released guidance to help healthcare organizations handle ransomware attacks. Today's timely program combines legal and technical experts in healthcare and cybersecurity to help you navigate through this critical area of your organizations. And our speakers today, I'm going to introduce them in order of speaking. The first speaker will be Tracy Miller. Tracy is at Bond, Schoeneck King, and she's a member of the Cybersecurity and Healthcare Practice Groups. Tracy's practice focuses on the issues posed by the transformation underway in healthcare delivery, including corporate governance, federal and state health reform, compliance, value-based payment, and cybersecurity and privacy. Tracy is the former general counsel of a health system of hospitals, nursing homes, home care, and other programs where she oversaw HIPAA implementation and compliance. She routinely advises clients about cybersecurity matters, including policy development, insurance, contracts, and governance oversight. Our second speaker is going to be Ben DeMonte. He's sitting in the middle. Ben is an associate managing director with Kroll's Cybersecurity and Investigations Practice, based in Kroll's New York office. Ben has led a variety of complex cyber investigations, including technical analysis for national security, network intrusions, insider attacks, malware infections, internet fraud, child sexual exploitation, and theft of intellectual property. Prior to Kroll, Ben was assistant director of the FBI's Regional Forensic Laboratory in New Jersey. And our last speaker is Raul Taboro of Bond, Schoeneck King, and Raul has over 25 years of experience in healthcare reimbursement and corporate compliance and enforcement. Raul has represented institutional providers and conducted internal investigations involving data theft, unauthorized computer tampering, and banking fraud. He has also negotiated IT contracts and litigated cases involving vendor IT breach issues and theft of trade secrets. Raul previously spent 8 years as in-house counsel with the New York Medicaid Reimbursement Fraud and Abuse Bureau. So our speakers will each speak for about 20 minutes, and then we'll take questions from here and all of our offices after that. Thanks very much for being here.
Well, Monica, thank you for the introduction. Welcome to all of you in New York City and in our offices in Syracuse, Buffalo, and Albany. It is a great pleasure to be doing the program today with Ben from Kroll and my colleague Raoul from Bond, Schoeneck King. It is hard to pick up a newspaper without appreciating that cyber attacks are increasing in intensity and sophistication, and as you all know, that the healthcare arena has long been a primary target. The average cost of a breach per healthcare record is now estimated at $350, with the total cost for breach reaching into the millions in any individual case. In a 2016 study of healthcare IT professionals, 63% said that they had experienced a breach, and 96% felt vulnerable. Monica's already talked about the mounting risk of ransomware, and I was really struck by a statement in the OCR Guidance fact sheet that was sent to the heads of healthcare organizations earlier this month. And that fact was that since early 2016, 4,000 ransomware attacks are occurring daily in the United States. A 2015 survey of boards of directors and general counsel at large corporations, when asked those being interviewed, what is the thing that most keeps you up at night? And the answer was that the leading risk that they see at present is the risk of cyber attacks. Unfortunately, attacks on small organizations are also on the rise. The Small Business Association reported that between 2012 and 2014, attacks on small organizations have doubled. And contributing to the challenges that all of you face in the current environment, the HHS Office for Civil Rights has accelerated enforcement action and dramatically increased penalties. I'm going to talk about some of the recent enforcement actions, and it is now in the midst, we are in the midst of a new rollout of audits by OCR. This slide was what I call the building blocks of an effective cybersecurity program. I'm going to talk about them throughout my presentation, but they should be part of all of your organization's cybersecurity programs. Certainly in the healthcare arena, the predominant body of law and regulation is HIPAA, I'm sure which you're all familiar for many years now. But there are other bodies of law and other standards that apply. The Federal Trade Commission oversees cybersecurity under Section 5 of the FTC Act and has enforcement authority and jurisdiction in relation to healthcare organizations, as well as many others that it oversees in the United States. The Payment Card Industry Security Standard is a standard developed by the major credit cards. They enforce the standard, and that applies to organizations, all organizations that accept, process, store, or transmit credit card information. New York State, as do many states, has its own Breach Notification Act that applies to organizations that own, operate, or maintain computerized data that includes personal information, and one point of that personal information is social security numbers. So that also includes many of your organizations. I'm going to talk about that act as well towards the end of my presentation. What I'm not going to do is an overview of HIPAA and the security rule more broadly. HIPAA's been around a long time. Not only do we not have time, but we have designed this program to focus on those issues that are most critical in the current environment. So one of the issues that I want to focus on is the fact that the HIPAA security standards are scalable and flexible. They were designed that way. They were designed that way because HHS and OCR recognize that technology will change. And just as important, that organizations in the healthcare arena vary dramatically in size, in complexity, and in resources. So they did not prescribe a particular set of security solutions. The OCR guidance recognizes that organizations are unique and that they vary, and so their security programs will vary. And measures are required that reasonably implement a security standard taking into account the size of the organization, its capability, the cost of specific security measures, and operational impact. And it's also recognized that organizations will balance risk of protective measures against the impact on their, or balance the cost and the impact of protective measures on their operations. And finally, in general, HIPAA is technology neutral. As I mentioned, it does not prescribe specific standards. In other words, with the HIPAA security rule, one size does not fit all. But what that means as we enter a world of value-based payment, and as New York State continues to implement DSRIP, the Delivery System Reform Incentive Payment Program, that'll be the last time I say the whole thing, but as New York State continues to implement DSRIP and lead organizations build integrated delivery networks that include organizations that range from small physician practices to nursing homes, home care agencies, hospitals, hospital systems, behavioral health providers, all of those entities may be HIPAA compliant, and they all have a different level of security and different security measures in place. So that is very important as an underlying reality that should be recognized as we move forward here in New York State. I mentioned that HIPAA doesn't mandate standards. There is one standard that HHS has embraced as a technical standard, and that is the standard for encryption that is set by NIST, so that if that standard is met, if the data is encrypted in accordance with the NIST standard and there is a breach, there is no obligation to notify. I've included on the slide the reference to the national standards put forward by NIST. They are not mandatory, but they are an excellent guidepost. And NIST recently put out a document that is quite helpful, that is a crosswalk between the HIPAA security rule and the NIST standards. And you'll see on the slide, and all of you should have a copy of the slides in your materials. You see the website, the link. Security risks in the current era of health system transformation have to take into account the fact that federal and state health reform has launched an unprecedented degree of data sharing across the continuum of care. You have an emphasis by payers on the triple aim and population health management. PPS leads and DSRIP are building population health management platforms, as are other organizations. The shift to value-based payment by all payers requires data sharing among providers and between payers, providers, and plans. And moreover, the Delivery System Reform Incentive Payment Program, or I said I wouldn't say the full thing, but DSRIP mandates data exchange as well across many different entities in the continuum. That data exchange is going to occur through regional health information organizations. It's going to occur as participating organizations provide data to the leads. The leads provide the data back out to the participating organizations, and the participating organizations communicate with one another in the PPS projects. And moreover, PPS leads that are operating in overlapping regions need to share data that identifies all of their participating Medicaid beneficiaries in order to avoid double billing or overpayment by DOH. So taken together, what that means is that more and more entities are holding or have access to increasingly large pools of data. There are steps that organizations can take to be proactive as in the face of this tremendous escalation in data exchange and data sharing. One is to do a risk assessment of a transaction or arrangement or PPS project in terms of how the data will be transmitted, stored, or used. You can, in each transaction, establish with your partners minimum security standards for particular arrangements. In addition, it's obviously increasingly important to allocate risk through indemnification and business associate agreements. Cybersecurity insurance has certainly moved from prudent to essential in the current environment. And for organizations that have not focused extensively on cybersecurity, I would say that now is the time to up your game, particularly if you are participating in DSRIP or you intend to participate in value-based payment. You are going to be sharing data and receiving data more and more from other organizations, all of which heightens your risk and your liability as a business associate in those arrangements. And finally, something worth considering in these arrangements is whether there should be and can be a negotiated time to delete the data. If the data is needed for data analytics for a particular purpose, and you only need to exchange the data, and yet neither or all the organizations don't need to hold it, then it should be deleted. It should be deleted because that's consistent with the minimum necessary rule under HIPAA, and also because that's prudent not to be holding that data if you don't need to. As we face this data exchange under health reform and escalating cyber attacks, certainly important to focus on what has always been core to a good security program, and that is risk assessment. The risk assessment should ask, what sensitive information does your organization create, use, transmit, or store? And obviously for healthcare organizations, the primary data is PHI, protected health information, but you're also holding employee information, financial information. Some of you may have intellectual property as well. As you do that risk assessment, you should identify your most likely risks and vulnerabilities by walking through this analysis. What are the means of access to the information? How does it flow through your organization? What are all the devices that access PHI? And I want to stop there for a moment because a recent analysis of the data breaches reported to HHS found that almost 50% of the breaches related to lost or stolen mobile devices, desktops, laptops, iPads. So certainly since the organization must always prioritize in their security program, if you're considering priorities right now, this is certainly one to consider for your organization. Consultants and vendors are at risk, and we're always going to talk more about that. And there are human, environmental, and natural threats, and I'm sure Ben will address those with you. But the one point that I want to make about the risk assessment is it's not one moment in time, particularly in this environment. And you can also be assured that if you are the subject of an audit or you're the subject of a government investigation because there's been a breach, one of the first documents that they're going to ask for is your risk assessment. And they're going to trace through to see whether you have carried out those steps that identified as necessary in that assessment. Studies have consistently shown that employees are the single greatest source of vulnerability, either through theft or negligence. Your employees, unfortunately, are essentially the Trojan horse in your cybersecurity program. It is important and required by HIPAA to develop a policy to limit access to PHI and other sensitive data to employees who need access based solely on their job responsibility. I should point out that HIPAA only covers, obviously, PHI, but as you're building your cybersecurity program, obviously you want to look at and consider other sensitive data that you're holding. You then need to set up a process to authorize only those who should have access, to restrict their access, and then to monitor their access. All of that sounds relatively straightforward, but it's hard to do, and it takes discipline across an organization. Morgan Stanley recently paid a $1 million fine to the SEC for failing to restrict data and failing to monitor access. In that case, an employee had moved information about 730,000 customers onto his personal server at home. That was hacked, and the data ended up on the internet. And basically, Morgan Stanley was severely criticized by the SEC for giving him access in the first place when he didn't need it, but second of all, for not noticing the tremendous download of data that was ongoing. And the other, obviously, critical elements of your program are training and awareness for employees, which also should not be at one moment in time, should be ongoing. I'm suggesting, and we think about this with our clients, about whether they should move from more passively distributing security policies to having employees agree to comply with the policies, particularly in the case of mobile devices. And then finally, it's important to implement procedures to restrict access when employees are terminated. A breach policy and response is a critical part of your cybersecurity program. You should have a written policy that is updated and tested, that identifies your breach response team and the leadership. One of the factors that you should address, or that plan should address, is a coordinated response between IT and legal. IT expertise is just critical to analyze a breach and mitigate damage, and you should know in advance of a breach or an event who is the IT person who's going to manage you through a serious breach. Likewise, counsel needs to be involved from the outset, whether it is senior in-house counsel or outside counsel, to advise about the investigation, to assess the risk, provide advice about the notice, and assure that the attorney-client privilege is protected. Just so you understand, if you call the IT consultant in first and they begin an investigation to understand what has gone wrong. Unless counsel is involved and the IT consultant is acting at the direction of counsel for the purpose of providing legal advice, whatever is identified in that investigation is not protected by the attorney-client privilege. You also need a communication plan with employees and a plan with the public and individuals infected by the breach, and also obviously if you need to provide notice, you need a plan to do that as well. I want to focus very briefly on ransomware. I know Ben is going to cover this as well in his presentation. It was striking in the letter that went out from HHS to the heads of healthcare organizations that the letter stated that this is not just a matter for your chief information officers, this is a major threat to all aspects of your business. The letter did point out, and the fact sheet pointed out, that there are certain core elements of HIPAA that can help protect against a ransomware attack, including a risk assessment, procedures to guard against and detect malicious software, and frequent data backup and robust disaster recovery plan. It's also important to note that if PHI is encrypted as part of the attack, it will be considered a breach, and then you need to walk through the same legal analysis, and in this it'll be a kind of mix of legal analysis and a technical analysis to determine if there is a low probability that PHI has been compromised. And that's a standard that applies to determine if you need to provide notice in accordance with the HITECH Act. And in order to do that analysis, you need to walk through the 4 points that are listed here and on the slide. Assigned security responsibility is a critical element of any effective program, and as all of you know, HIPAA requires that you have a security officer, but that is something that should be taken very seriously in terms of how the person is positioned within your organization. That person needs to have the authority, the responsibility, and the visibility to fulfill that role effectively. And I've listed a number of questions here that should be asked about the role on the slide. Moving to the third bullet, important to ask about the reporting line and to consider the reporting line to the CEO, the president, or other senior officer, so that your security officer is in a position to shape policy, to influence operations, as well as management decisions. Does the individual report to the board periodically? That's, for those of you who are compliance officers, that's a question that you're going to recognize. Important for both the program and the visibility and the board's ability to fulfill its fiduciary duty, that there be a report to the board. Is the person integrated into business decisions and transactions? That should be the case at the outset so that your organization can assess the risk and weigh that risk as it considers the transaction overall. And finally, what is the coordination between legal counsel, the security officer, the compliance officer, and the privacy officer? There's no one blueprint for that coordination, but it is important that it be in place. As with healthcare quality and compliance, governance oversight is a core foundation for your cybersecurity program. Target was certainly a wake-up call. There was a shareholders' derivative suit against the board for certain actions that it was alleged or certain responsibilities it was alleged to have failed. But given the risks in the current environment, there's no question that your board should have an active role in overseeing cybersecurity. A board role is essential to establishing a culture of compliance. The governance structure can unfold in a number, be set up in a number of different ways. It can be reported up through the compliance committee. More and more healthcare organizations have a data and IT committee. The report can go directly to the board. But what's important to remember is the precedent set by the seminal case of In re Caremark, which held that boards of directors do not have a duty to proactively investigate or seek out problems, but they have an irreducible duty to ensure an adequate reporting system up to them to fulfill their duty, and that now certainly includes cybersecurity. Boards should be trained about cybersecurity so they feel knowledgeable enough to carry out their responsibility. It is prudent or good practice for a board to approve a cybersecurity plan, and to assure that there are adequate resources. And in terms of that reporting up to the board, it should include reports on the risk assessment findings, major security incidents, and remediation. You are all very familiar with business associate agreements that are mandated by HIPAA before covered entities can share protected health information with vendors or contractors. I have listed the first 5 bullets with some of the mandated provisions for a business associate agreement. The last 3 bullets are provisions or issues that are not mandated but can be negotiated. Indemnification is, as I mentioned, an increasingly important element of business associate agreement to allocate responsibility for the cost of notice, remediation, and other aspects of a breach. The agreements can specify certain minimum necessary practices, such as encryption, since those are not mandated by HIPAA, but have become industry standard. And moreover, they can address the right to information about security practices and systems. And certainly you ought to consider that as part of your due diligence before you enter into a transaction or a business associate agreement. I mentioned that cybersecurity insurance has become more and more essential in the current environment. It's critical not just to have insurance, but to know what it covers and to be sure that it covers what is important to your organization. So I've listed here all of the different elements that cybersecurity insurance can cover. It can cover the cost of investigation, the attorneys and consultants cost, the response to regulatory enforcement. Very common for the policies to cover business interruption costs. The policies can cover notice to individuals. They can cover potential civil liability. HIPAA does not provide for a private cause of action, but we have seen more and more cases, class action cases by plaintiffs asserting different remedies. There's a major suit seeking $57 million in California against a group of cancer care providers under California's confidentiality law. Going back to the list for the policies, they can also cover liability to business partners, your business associates. They can cover loss of data and or intellectual property. Many of them include some costs for public relations services, and increasingly the policies can and do cover the cost of ransomware. It's important as you look at your policy not just to look at what areas are covered, but what are the coverage limits. There are limits that can apply to each one of these areas, or there may be a global limit for coverage, and also there may be exclusions under each one of these areas. And I guess before I leave the slide, I just want to underscore that there is no standard cybersecurity policy. This is an area of business practice that is rapidly evolving, and the policies vary widely. I want to just cover quickly some of the recent enforcement actions by the Office for Civil Rights. One was an action against the University of Mississippi Medical Center, resulting in a $2.75 million settlement for a breach of 10,000 individuals' data. In that case, there was a theft of a password-protected laptop, but it was not industry standard complexity. It had a generic password, and what OCR found when investigated is that the system had been aware of its vulnerabilities since 2005 and had not sufficiently addressed them. The Oregon Health and Science University settled for $2.7 million. In that case, it entailed the theft of 2 unencrypted laptops and a large breach from an unencrypted thumb drive. They had placed, in addition, the university had placed data for 3,000 individuals with a cloud storage company, and there was no business associate agreement. And what OCR concluded is, even though the entity had done a risk assessment every 2 years, and I'd certainly argue that's not nearly frequent enough in the current environment, they had not covered the whole enterprise in the risk assessment, and they had not followed up on the problems that they found. Catholic Health Services of Philadelphia settled for $650,000 as a business associate to 6 nursing homes in its system, arising from breach of extensive information about residents. In that case, the system parent, very common arrangement, was providing IT services to its member nursing homes. In that case, it was a CHCS-issued smartphone that was stolen, and it did not have a password, and it was not encrypted. And finally, the Raleigh Orthopedic Clinic paid $750,000 for releasing data for over 17,000 patients to a contractor without a business associate agreement. So I just want to point out that seems like a relatively minor infraction, something that can happen easily, a common occurrence, but that's precisely the kinds of issues and shortfalls that OCR has focused on. And these are some of the higher penalties that we've seen, and they are increasing in frequency. As I mentioned, OCR has rolled out a series of enforcement audits. They start with a relatively simple audit questionnaire. Entities that receive that questionnaire some will be selected for an audit pool that will either be a desk or an on-site audit. There is an audit protocol on the OCR website and you can see from that the very extensive amount of data and questions that they may ask when they come in for an audit. That includes asking for your written risk assessment, the prior risk assessment, and updates, and what you've done to address the risk assessment. I also want to point out with these audits that they are asking covered entities for the names and contact information for their business associates, and business associates will be on the next round of audits. And there is in your materials an article about these audits. In closing, I just want to mention two other bodies of law that I referred to at the outset. One is the Federal Trade Commission oversight. The FTC oversees cybersecurity under Section 5 of the FTC Act, which governs enforcement of unfair and deceptive commercial practices. There is an article that goes into detail in your material about the FTC v. Wyndham Corporation case. It was a very important case by the Third Circuit, which upheld the FTC's jurisdiction over cybersecurity. And the case is useful because if you wanted what not to do in your cybersecurity program, there's a list there of Wyndham shortfalls. But essentially, Wyndham had been hacked 3 times in 2 years, resulting in the breach of credit card information for 619,000 customers. And what the FTC found is that they were hacked the second and third time because they never closed the door effectively on the hackers the first time. And finally, I just want to close by, I realized I'm sorry I did change the slide on the FTC, but these are the standards I was referring to in the case I was referring to with respect to the FTC, and as I mentioned, that article is in your materials. And finally, I just want to close by talking about the New York State Breach Notification Act. The entities that must comply are individuals, organizations, and businesses that own, operate, or maintain computerized data that includes private information. And that private information is social security numbers, driver's license numbers, or credit card or financial account information in combination with the pass or security code to the account. And if there's an unauthorized release of the information or disclosure, there must be notice to those whose information is disclosed without unreasonable delay, or there has to be notice to, if there's a business associate, to the organization that provided the data. And the notice, if you have to notify New York State residents or individuals, you also have to notify the State Attorney General, the Department of State, and the State Police. So with that said, it's my pleasure to turn the program over to Ben.
Thank you, Tracy, and thank you, Schoeneck and King, for inviting Kroll to come and do this presentation. Thank you. My name is Ben DeMonte. I'm an Associate Managing Director at Kroll's Cybersecurity here in New York. Some of the things we're going to talk about during my presentation, we'll try not to get too technical. But it's talking about the security risks, some of the investigations that Kroll has conducted, some of the lessons learned from those things. Healthcare organizations, why are they different? We know that threats and the risks apply to many organizations, whether it's financial or healthcare, but there are things that are different in healthcare organizations. Some of those are in a smaller healthcare system. IT may be not part of the organization. It may be a third party. Clinical systems may not be administered by the in-house security team or the in-house IT system. They may be done by another party. Remote healthcare adds a level of complexity to your organization. We spoke about some of the regulations where mobile devices, whether it's a laptop, cell phone, or tablet, needs to be encrypted differently. And then the consolidation that I think naturally happens within healthcare organizations. As healthcare organizations merge, you have healthcare organizations that incur sort of the cybersecurity program of whoever they're consolidating with. In some cases, that cybersecurity program may be better than yours, and so maybe there's some advantages, but in some cases we see that it's deficient, and you are incurring all those risks. Some other things are the sharing initiatives that we talked about, and as healthcare institutions have been accepting credit card payment, that adds another level of complexity, another level of security requirements that the IT staff needs to address. Threats and risks. Removal of termed employees' access to systems. Again, speaking to some of the investigations that Kroll has done, we still see that as employees leave organizations, their credentials are not removed from the system. And whether it's a disgruntled employee or maybe a curious employee, so to speak, we have former employees coming back into the system, downloading whether it's HR records of the organization or in some cases accessing healthcare records. Accounts not following normal security rules. We see this a lot with third-party organizations, meaning that you have a set of security rules that you follow, certain policies that you follow for certain accounts, and then you give exceptions to whether it's your IT tech support or whether it's some other third party, because in some cases it's just easier for that third party to access the system. So although, as an example, VPN, which is access into your network, may be restricted to only a few individuals, we see that sometimes that access is granted more broadly to these third parties. And in some cases, that imposes some high risk. And then system administrators, accounts that have elevated privileges on the system should be treated accordingly. They should be audited more regularly. Those are the keys that hackers will try to find because they are the credentials that give the broadest access into the system. And then endpoints. When we speak of endpoints, we're talking about a computer, a laptop, a server, maybe a tablet, maybe a mobile device. But most organizations, specifically healthcare organizations, have no visibility into their endpoints. They don't know what software is necessarily running on those endpoints. They can't take a malicious alert that they get from some other security product and run it back to a machine and to an actual process that was running on that machine. And from our perspective, we think that some of the greatest risk into healthcare organization networks are endpoints. Clinical systems, I think, add another level of complexity to this. We see that a lot of clinical systems are running very old versions of certain operating systems, maybe operating systems that are end of life, but yet those systems are still attached to your network, and in some cases users who authenticate to the more secure systems can still authenticate to some of these systems that are less secure. And then mobile devices, as we spoke about, or as Tracy spoke, about them being encrypted, password protected, having the appropriate level of complexity for those passwords. We are going to talk a little bit about ransomware. I think that's sort of the sort of hot topic right now. We've all read about the events that have happened over the last probably year. Ransomware goes back much further than that. but lately there has been a large campaign against healthcare organizations, and we can talk a little bit about why that is. And then lack of logging. We find that when healthcare organizations experience some sort of event, that logging or the lack of logging is always the core of the issue. In some cases, it does not allow the third-party forensics company like Kroll to really do an efficient or an effective investigation, because there's just not enough forensic evidence for us to conclude whether or not data was actually exfiltrated from the system. In some cases, that puts the attorneys in a precarious situation, because without us telling them that it wasn't, there may have to be an assumption that it was exfiltrated. PHI found on the internet, insider versus an intruder. In some investigations, that's very difficult to conclude. We still see a lot of exfiltration of data or damage to data, specifically in healthcare organizations. When I spoke a little bit about that disgruntled employee, over probably the last, I'd say, 6 to 8 months, we've done a number of investigations in which the disgruntled employee comes back into the network and just deletes data. Doesn't really take it, isn't really interested in it, probably doesn't know how to monetize that data, but because they're disgruntled, they're just going to go in and delete it. And then that puts a whole chain of events in effect, whether or not you have an effective backup strategy. In some cases, we've seen the backup strategy get deleted. We'll speak a little bit about, there's a point here about virtual machines. In one instance, not only did the individual, we had one investigation in which the disgruntled employee specifically deleted the virtual machines because he wanted to make sure that the backup strategy would not work. In another case, accidentally, some virtual machines were deleted, and that caused a large disruption within that healthcare organization. And I apologize, I see some folks looking. Virtual machines are really just software that makes one computer act like many computers. You can install a machine virtually on one physical computer, and you can run many of them. It's sort of it's the latest technology in attempting to make the footprint of data centers and computers just smaller. So. We'll talk about ransomware here. So for those of you who don't know what ransomware is just a malicious program that gets installed on your system and then upon execution encrypts your data. When ransomware first started, it really encrypted Microsoft Office documents, Word documents, Excel documents, and things like that. It has morphed into, for all intents and purposes, encrypting any file that has any meaning to the user or to the organization. It encrypts, some versions of ransomware will encrypt SQL databases, which are probably where you keep your patient records. It'll also, in some cases, encrypt your Microsoft Exchange environment. So not only is your electronic patient record system down, but so is your email. That makes it very difficult to operate any organization. It usually requires payment. It originally, payment was done through a bunch of different mechanisms. At first it was to wire money. Now, of course, it has moved to Bitcoin, because Bitcoin is very difficult for law enforcement to trace. And so the money just goes somewhere and someone collects it, and there's not much we can do about that. We'll talk a little bit about the different variants of ransomware, but in some cases, ransomware can infect one computer. So someone receives a malicious file. It could be a file pretending to be something else, or it could be a Microsoft Word document. that file the user typically will launch it, will try to open up that document. It will infect the one computer and any network shares that computer has access to. And so, as you can tell from my last point, this can be an annoyance. Although some of the latest OCR guidance may change that to be more of an event. But in some cases, it's easy to recover from one computer and maybe one or two network shares. In the latest versions, or in one particular variant that we're going to speak about, it infects every computer that's attached to your network. So any computer that allows a user to log into gets infected. The way the attacker does this is they're not sending you a particular malicious program for you to run. What they're effectively doing is they're initiating an intrusion into your network. They then find all the machines on your network and they install the ransomware program on every single machine. They then hit go and then they leave. Within hours, every machine on your network will be encrypted, every database, potentially your email system, and then of course, as you know, everything will go down. Some of the latest news articles talk about hospitals, healthcare institutions being down for weeks in order to be able to recover. In some cases, that ransomware will delete backup systems, whether it's virtual machines that we spoke about, or any kind of online backup storage. In one instance, we even had it affect some cloud storage that the organization was using because the cloud storage had hooks into that network. And so, excuse me. So as the actor was enumerating the network, that cloud storage just looked like it was local to the network. So it in fact got encrypted. Here's some examples of some of the screens. They vary. Some of them have gotten sort of fancy. They put up FBI banners. There was even one variant that said that your machine there has been child pornography found on your machine, and if you don't pay the ransom, they're going to tell the FBI that your machine in fact had those images. In some cases, there's a timer that says that you need to pay the ransom within a certain amount of time, and if you don't, the data will be deleted and nobody will ever be able to recover it. And in some cases, the price goes up the longer you wait. A closer look at ransomware. Again, email is a huge sort of risk there. In a lot of cases, hackers, instead of trying to get into your network, the easiest way for me to get a program installed on your network is to just email it to you and trick you into clicking on it and installing it for me. In some cases, we've seen legitimate websites get compromised, and so a user thinks they're going to a legitimate website, but that website in fact has been compromised and is now hosting ransomware, and so the ransomware gets loaded on the machine. And then the intrusion. It exploits vulnerabilities and then it moves laterally through the network. So what that means is they find a computer on your network that's accessible from the internet. They find some publicly known vulnerability. They exploit it, and now they have full access to your system and to your network. If you look at the bottom right-hand corner, JBoss is just a program that's used on certain web servers, and those web servers are known to be used in healthcare industry. Cisco reported that 3 million servers had vulnerable versions of JBoss on the internet. So that's potentially, if you think it could be potentially 3 million victims. Some organizations have multiple servers, so the number would be less. I'll talk a little bit about the latest OCR guidance. Clearly, I'll leave that to the attorneys to discuss more broadly.
Ben, just a question. When you say vulnerable servers, what do you mean by that when they don't have the right version, say, of that JBoss?
Thank
program?
you. That's a good question. So yes, in some cases, the application has not released a patch, and so a known vulnerability is known to the community. In other cases, because of maybe the way IT is split within healthcare organizations, you have one IT department that's keeping all systems updated, the latest Microsoft patches, the latest security patches, but then you have another group that's looking at more production servers, and though that group maybe is not updating their servers. So a lot of these servers have been known to be vulnerable since 2014, and so 2 years later, they're still not updated, they're still vulnerable. In some of the cases that we've worked where we've conducted investigation into the ransomware, we find that the server had been accessed by an attacker 2 years prior to the ransomware event. And that's because of these known vulnerabilities. It's very, very easy to exploit a server that has a known vulnerability. It's as easy as downloading a program, pointing it to an IP address, and saying go, and it just then tells you, and in some cases, just gives you access to that server. Some of the names, CryptoLocker was sort of shut down by law enforcement and the security community in May of 2014. That's after they made about $3 million in Bitcoin payment, Bitcoin ransom. If you think about that, in the original kind of CryptoLocker variants, in some cases, the Bitcoin ransom was only $500. So to get to $3 million, there were a lot of victims there. CryptoWall and Locky, again, these are just other names. That was mostly distributed through some sort of email or spam campaign where they send out an email to multiple individuals and hope that somebody clicks on it. Tesla Crypt was also a sort of email distribution. That was the mechanism. But it exploited known vulnerabilities in Adobe, and so they would trick you into, in some cases, installing a piece of software, thinking that you were doing an update, or in some cases, they would just exploit a known Adobe vulnerability. SamSam is sort of the, for about 3 months, we saw it hit healthcare organizations across the country. SamSam is the variant that affects every machine in your network all at one time, in essence shutting you down for a number of days and weeks, depending on how long it takes you to get back up and running. SamSam is that intrusion. By its nature, it's not something that's emailed, it's something that needs to be installed and run. And again, Cisco reported 3 million servers. I think I have one more slide. So latest OCR guidelines, again, folks here are much more experts in interpreting OCR guidelines than I am. There was one sort of interesting, sentence that I saw, and it said, a breach has occurred because the ePHI encrypted by the ransomware was acquired. Anytime you use the word, that the attacker acquired the data, that obviously leads to other conclusions. I don't necessarily think that in a lot of these ransomware cases, the attacker is acquiring the data. They are simply encrypting the data in place. But again, these are the guidelines. Everyone should be aware of them. Talk to your inside counsel or outside counsel on how this affects you. What can we do next? Endpoint threat monitor visibility is key. Understanding and having visibility into what your endpoints are doing, what programs they're running, if those programs appear to be malicious, is key. Incident response plan. As Tracy brought up, having an incident response plan is very important, and then testing that plan is much more important. Having that plan sit around where only a few individuals who probably no longer work for the organization wrote doesn't do any good if the current staff doesn't even know what the plan looks like. And of course, that plan changes as your security model matures, as you add security technologies, remove other technologies, that plan needs to change. Security assessments. Not just vulnerability scans and penetration testing that sort of has been around, those kind of things have been around in the industry for probably more than 20 years. But folks sometimes forget to just look at their accounts on their system. Are we seeing accounts that are not being removed because they're former employees? Or do we see strange accounts being created on the system? We do find that attackers, once they have access to the system, they will create new accounts on your system so that they have access if you are to remove sort of their vector into your network. They'll just log on in what appears to be from a legitimate user, because you won't know that that user actually doesn't exist. So doing that system account audit is important. And then two-factor authentication. So two-factor authentication in its simplest form means when you log on to a system, you have a username, you have a password. Two-factor is something else. That could be an application that's running on your cell phone that gives you a 5 or 6 digit random number that you have to type in addition to your password. Or in some cases, it's the RSA token or key fobs that you see folks running around with. Those numbers change every 90 seconds. And so if someone was to either trick you into giving up your credentials through some phishing site, or you use the same password for some other system, maybe a personal system, and that system was compromised, and attackers then try to use those stolen or harvested credentials for all systems, two-factor fixes the problem. It's not a sort of silver bullet into all your security issues, but it eliminates the risk of your credentials. So your credentials, if exposed, are really worthless to the attacker because you have this sort of second factor. When we talk about two-factor authentication into systems, that means all your HR portal, your electronic patient record portal, and your email system. We still see a large amount of healthcare breaches happening because unauthorized access into someone's email system. Maybe it's someone in payroll, maybe it's somebody in record keeping, and so they just naturally have a lot of PII or PHI system in their email, and of course it's been accessed by an unauthorized person, so there's potential disclosure. I think we're holding all questions till the end, right?
Yes.
There you go. Thank you.
See if this works. I think we've been talking about plans, and had done a presentation right after Hurricane Sandy, and all the best laid plans were, I got punched in the face because things happen. And I think that one thing that we can assume is that you will be hacked, and there will be blood. So a lot of the focus, I think, over the past year is, okay, we need to do prevention, but we have to have a contingency plan. We have to assume the worst. Now, my presentation will focus on two themes. One is vendor relationships and building in risk and risk assessment into your vendor relationships. A lot of healthcare providers may not have a robust IT staff, and you may have outsourced. Even if you do have IT staff, you are outsourcing a lot of your services for IT purposes to an outside provider or an outside vendor. And all of those areas will be scrutinized as we move forward. These are the main risk factors as we've seen them: a failure of system design, failure to train. I have a multitude of devices, portable devices. If I do not update these, or I have somebody update these for me, that is a big risk area because I have access. These are one of the endpoints I think that Ben had referred to. I think the iPhones are a little bit more robust in terms of getting those updates, onto the iPhone system. But training is key, and when you're using vendors, building in your training program into the contracts will be important. Failure of vendor relationships, as we'll talk about later. There may be disgruntled employees. There may be disgruntled employees of your vendor, which is oftentimes the worst type of attack, because it's very difficult for you to control your vendor's employees. Failure to monitor, failure to prepare for a successful attack, and failure to report. What was interesting about, I don't know if you followed the Democratic National Convention and the WikiLeaks problem that came out. And as I'm going back and I'm trying to do a root cause analysis, how could this have happened? It's interesting that back in December, there was a failure in the DNC system in terms of unauthorized access by the Sanders campaign. And the cause was noted to be a firewall kept going down, a firewall in the system. And it was a design defect. So it was a defect and a failure of system design. WikiLeaks, or whoever's out there, would have read that. And of course, it was easy pickings, I think, as Ben had indicated. The themes are vendor relationships and also trying to stay ahead of the law. The law in terms of cybersecurity is changing. This year, next year, we're going to see substantial changes. The Cybersecurity Act of 2015 was enacted into law this past December, one of the few things that Congress and the President agreed on. There had been committees looking at third-party contractors and vendor relationships over the course of 2015. And you'll see that changing. We want to stay ahead of the law. In terms of vendor risk, I always am looking at risk. As what I was trained to do, legal risk. When I review contracts, when I manage contractual relationships, I see things as a vendor risk cycle. There's risk that you try to identify in the due diligence process. So you try to expect the risk that will occur. Contract terms, utilization of acceptance criteria. Where is the data center? Who is storing the data? Oftentimes your data may be in Nebraska. Do you have a good backup in terms of that data? That should be included in the risk analysis and in your contractual terms. Subcontractors. Your vendor may be using a subcontractor who has a server colony someplace. So your vendor may say that they have the data, but it's actually being maintained by their subcontractor. What's the contract look like between your vendor and their subcontractor? And of course, vendor employees and turnover. We'll see that monitoring of security standards under the Cybersecurity Act of 2015 and some other regulations that went into effect over the past couple of months is a key area. When you look at a contract, oftentimes you have a contract, it's supposed to be in plain language, but there's a lot of criteria that need to be built into IT contracts. Acceptance specifications oftentimes are hundreds of pages in length. And we look to encryption standards. There was a mention of the National Institute of Science and Technology standards, which are themselves hundreds of pages long. It's very important to build in acceptance criteria, which addresses the encryption standards, data center standards, continuous monitoring, and external audit standards, which is an area that I've had trouble with in terms of the vendors agreeing to an external audit. That's going to have to be a bright line. That in negotiating a contract, you want to have the relationship that they're a good vendor, but if they're not allowing for external audits in the future, that's going to cause problems for you. The laws, it's important to understand that the laws set forth minimum standards. They're intended to apply to everyone. we try to build in best practices, and not just industry standards or minimum legal standards, but best practices. A question that often comes up is, well, HIPAA requires encryption. And many people believe that HIPAA security rules require encryption. They don't. That is called an addressable security area. We want to have encryption because if you have encryption and it is fully functional and you're updating all of your systems properly, it will protect you from those fines that Tracy had mentioned. And we've talked about the ransomware guidance. I think that this is an area where you're going to see changes in the law, I'm sure, because the HIPAA encryption or non-encryption standard goes back to 2000, 2002, and a lot has happened, since that time. So what OCR is trying to do is interpret their regulations in a way which will capture the ransomware issue. Ben, one issue in terms of preparedness is I have to pay somebody in Bitcoin. I don't know how to do that. Do they give you instructions on that?
They absolutely do give you the instructions. Some of the issues is that you can't buy a large amount of Bitcoins for the ransoms that are larger, more than $500. The government has put some restrictions on buying large amounts of Bitcoin, and so it's difficult. In some cases, your city may have Bitcoin ATMs, but they typically have a limit, and so you may have to go to many ATMs.
Okay. So you can get them at ATMs?
There are Bitcoin ATMs, yes.
Really? Okay.
Yeah.
And, as I'm listening to this and we've, seen this play out, the ransom will increase. So you have, half an hour. Okay, it's, $1 per file or $10 per file. Now it's going to be double that and triple that if you wait until tomorrow. Just a sample of contractual terms. As the Sanders campaign was accused of accessing, I think this is a good analogy because everybody, I think, is focused on this. They were accused in December of accessing Hillary Clinton's voter registry, or the registry files of who she would contact. And they said, well, you didn't have authorization to do that, under whatever contractual agreement he entered into. So you'd look to the standard. I mean, if I'm assessing that issue, I'd say, well, what was the standard? And the standard oftentimes that I see is the minimum standard that the vendor will assure appropriate authorizations and protocols for access into the system. Whereas we try to negotiate a more robust standard of actually defining who the authorized user is. And an authorized user ceases to be an authorized user when they no longer are an employee of the healthcare system or of the contractor. And they are to revoke their privileges, change their access code, so on and so forth. Later we'll talk about a case where somebody leaves the vendor, doesn't use his access code, but uses a supervisor's access code to gain access into the system. So there's a lot of areas that not only should you be looking at it from a risk perspective in terms of monitoring this, but build it into the contracts. Because, as I said, there will be blood, and you don't want it to be yours. So the way that you ensure that is to make sure that the finger is pointing at the responsible party. We spoke about NIST standards. I had this slide up because they're all accessible on the web. So if you go to the National Institute of Science and Technology, you can read over the course of your vacation these 40 to 50 to 60 page documents. Encryption, for example, for data in motion, encryption for data at rest, which incidentally is one of the areas that when you're doing due diligence of your vendors, most vendors are not encrypting data at rest, meaning data that's on their servers. They're doing it over the course of the last couple of years. But that has been one of the areas that we've seen to be deficient. Now again, you're in compliance with the law. You're not in violation of the law because HIPAA does not require encryption. It requires that you address the encryption issue. But that is a risk area. And as I said, you want to stay ahead of the law, and the law is changing. These are segments from the Federal Acquisition Regulations, FAR. And if you look at licensing agreements that you might have or other IT contracts, you'll see references in the boilerplate to, quote, FAR regulations. These are the acquisition regulations for the federal government, mostly in the Department of Defense. Just this past May, they had enacted a final rule concerning information systems. And information systems are those systems that I mentioned would be in Nebraska, say, or some other location, or in your own organization. And these are safeguard requirements, which in many cases have been, good things to do. And you want to protect, as I think Ben had indicated, many healthcare organizations are looking at compliance with the law, but you really should be looking at successful risk assessment and implementation. And that's what the government is doing now, is trying to put in those successful strategies. And I think it's critical to take a look at these regulations, compare them to your contracts, and to determine, are you limiting information, or is your vendor limiting information in terms of authorized users? Are you limiting that access to the system? Do you have verification systems and control mechanisms? Can you identify information system users? So those logs are critical. And they will either support you or sink you. That's true, because then it's going to be very easy to see who had access to the system. So if you're not monitoring your logs, they're going to be monitored 2 years later during the investigation. Are you sanitizing and destroying information in a HIPAA compliant way or in a FERPA compliant way, whatever the standard may be? Limiting physical access. This is another area that I think many organizations may not look at. Your maintenance, outsource security, outsource maintenance, outsource cleaning service providers, they all are potential, even more lethal risk factors in your assessment, because they could come in and, after everybody leaves for the day, and have full access to many of your PC devices, or implant things that once somebody starts up the computer, they're able to do their work. In sophisticated systems, escorting visitors, monitor visitor activity, keep logs of visitors that have access to your information systems, implement subnetworks, identify, report, and correct, provide protection for malicious code, update malicious code protection mechanisms. Some of the cases that Tracy mentioned, you try to do a root cause analysis and you say, okay, why did that happen? So that now you can protect yourself and assure that that's not going to happen to your organization. One of the ways that you can do that is by making sure that you have a system, your IT staff, your CIO, your Chief Information Security Officer. In some organizations you have a CIO and a CISO, is making sure that you're looking at the advisories. I think one of the critical items I think Benjamin had noted is it's easy pickings when you know that there is a problem or an update or a patch that has been recommended, and it's on an advisory. This is the New York State Department of Information Systems. They've been increasing their vigilance over the last 5 years on the state level, New York State level, and they post those advisories, and they come from a variety of sources, including Cisco and other manufacturers of these systems. So if you're not accessing these advisories, there's going to be penalties, and there will be significant problems. One of the handouts that we've provided is an issuance of the Department of Justice. Best practices for victim response and reporting in cyber incidents. This came out in April of 2015. And that's a very good, well-written piece of guidance in terms of how do you respond, moving on to the enforcement side, to these attacks once they happen. Tracy had mentioned the importance of attorney-client privilege. In many of the investigations, once we start, or before we start the investigation, we need to have the IT specialist, the expert, under contract with the law firm, what we call a Covell agreement. And that preserves the confidentiality as they're coming in to do monitoring. And they will set up a monitoring system and do all kinds of diagnostics to find out where the problem is. All of that material should be subject to, in the early stages, eventually you might have to disclose it, but in the early stages you want to have that subject to a confidentiality agreement. Remedy reporting, having your backup, doing cyber breach drills, all of that goes along the theme of prepare for the worst. One of the final items that I'll talk about is reporting of incidents. Now, we all know that there's breach reporting and there's an assessment process. A new trend is trying to encourage the industry, businesses, to report unsuccessful breach attempts. And the importance of that is so the government industry can build up a database of these unsuccessful attempts and how you may have resolved it. So they're developing advisories that can be issued on this so that others can learn of these attempted breaches. This is something that was put out by the FBI and available on the web. When to report to the federal government, when to report to law enforcement. We mentioned the insurance, your insurance policies. And your insurance policies may require that you report to law enforcement before they're going to, or as part of their coverage determination. The Cybersecurity Act of 2015 includes protection for voluntary disclosures. These are disclosures you're not mandated to make by law, but you're helping out the government so that they could build a database of cyber attack incidents. So you will be protected from lawsuit. There is no duty, so you don't have a duty. It's nice that they put this in the law. There's no duty for you to report, and there's no duty for you to warn. Because again, when you've been attacked, you've successfully defended against it, it would be nice for others to know. But you're not going to be sued if you don't warn them. This is a case that we had brought against that vendor, that wayward employee of a vendor who had breached the security systems. Just to give you an idea of the causes of action which are available, there are private causes of action for a business that has been successfully attacked. Violation of Computer Fraud Act, Stored Wire Electronic Communications Act, Federal Wiretap Act. Each one of these provisions, while they also could be used for criminal prosecution, they contain civil sanctions, civil penalties that can be asserted by businesses that have been subject to attack. And then we include some common law causes of action of conversion and unfair competition and misappropriation.